Hello students, welcome to Module 2 of CRJ 470. As stated in the previous lecture, PowerPoints will cover major themes from the readings, but will not be a replacement for them. It is merely a guide to supplement the readings. I highly suggest that you complete the readings before you continue with this PowerPoint. This PowerPoint will be briefly covering the bail reform movements in the context of major reforms in the use of discretion. There will also be slides on the intersection of politics and the use of discretion, and how discretion is utilized along several major decision points in the CJ process. Lastly, there will be a brief discussion on the bail setting process as an attempt at discretion reform and control in the United States. As you already know, you should have read Chapter 3 in Taming the System before going through this lecture. In Chapter 3, Walker discusses the significance of the two bail reform movements in the United States. Until the early 1960s, there were essentially no interest in the problems associated with bail. You should think about the following as you read the chapter, or review the chapter. Why did the first bail reform movement in the 1960s occur? What was the significance of the Bail Reform Act of 1966? How was this bail reform movement cut short by opposing political forces, such as preventative detention? You should also be able to assess the importance of Caleb Foot's critical research on preventative detention and the effects it had with respect to conviction rates and subsequent prison sentences for those that were convicted after being incarcerated pre-trial. As mentioned by Walker, the people pushed for reforms as a way to control judicial discretion. There were two bail reform movements. The first bail reform movement emerged in the 1960s and emphasized justice for the poor and sought to reduce pretrial detention of criminal suspects. Pretrial detention is a concern because Foot found that people detained before trial were more likely to be convicted compared to those who weren't. The second bail reform movement focused on crime control due to the rising crime rates by seeking preventative detention laws designed to allow judges to deny bail to defendants deemed dangerous to the community. Although the first bail reform movement did reach its goal of reducing pretrial detention, it wasn't really successful with controlling discretion, as the judge still had the option to deny using the release on recognizance option. The movement also failed to alter the bail setting process, but instead may have strengthened them. Additionally, no attempts were made to control the bail amount, which differentially impacted the poor who couldn't provide the funds to make bail. The second reform movement didn't fare much better in terms of reducing crime and controlling discretion. Judges do not want to release offenders deemed dangerous, but they are not very good at predicting future criminality. Additionally, these decisions are based on empirical evidence. The reform movement at least attempted to make the decisions more empirically sound by providing accurate information about the defendant. Regardless, the second reform movement and the federal Preventative Detention Act of 1984 was extremely successful in rewriting the law of bail and had a ripple effect on the states as it applied to restrictions in bail setting in state courts. For example, see U.S. versus Salerno 1987, where the U.S. Supreme Court upheld the use of preventative detention, which means that when a defendant poses a demonstrable danger to the community, preventative detention passes constitutional muster. Judges are influenced by political pressures. They don't want to release on recognizance in more punitive states because they will appear too soft on crime. Additionally, bail is more visible than in the past. The judge's perception of the defendant's dangerousness is still of paramount importance. The second bail reform movement simply brought this idea out into the open. Consider what factors go into the bail determination process. From a fundamental standpoint, The question is to release or not. Subsequent to this, the decision then is based on a variety of situational factors. It is crucial to remember that in theory, bail is not a form of punishment. Bail is what we require to be posted via money or collateral to reasonably assure the court that the defendant will return to the court for all of his required court appearances. On page 57, Walker gives you a nice indication of who and what goes into the bail determination process. These processes, as you might imagine, require considerable amounts of discretion. Seriousness of the offense charged is probably the most important consideration. The prosecutor is the judge's primary source of information. Of course, the police officer supplies this information to the prosecutor, at least as it relates to the present offense charged. The prosecutor then has to consider the nature of the charge plus the prior record of the defendant in an effort to fully appraise the court of the facts necessary to make a bail determination. Keep in mind that the bail decision is highly visible. At the state court level, most judges are elected officials compared to federal judges that are appointed. How might this shape a judge's ideology toward the bail setting process? As mentioned, bail decisions are a complex and somewhat collaborative process. For the most part, bail is a conscious decision to detain people deemed dangerous. Subconsciously, though, these decisions are biased and based on supposition and stereotypes. Ultimately, the bail decision is in the hands of the judge, but there are several different criminal justice figures that can influence this decision. At its core, the basic decision is whether or not to release a defendant on their own recognizance or set monetary bail. Both options require a considerable amount of discretion. Even if judges release on their own recognizance, they can impose any number of conditions for such release, such as undergoing treatment, getting a job, etc. One actor that can influence the bail decision is the police. The way the police records the offense will shape the decisions of other criminal justice officials down the line. More serious offenses garner harsher punishments and higher amounts of bail. The police can also influence the decision on how they talk about the suspect to the judge. If they relay more derogatory information, they can influence the judge to believe the suspect is more dangerous. Prosecutors are arguably the most influential figure in the bail setting decision. Not only do they set the formal charge, which could be revised from what the police filed, they are the judge's primary source of information about the defendant. They may also make recommendations about bail. As mentioned in the book, one study found that judges followed the recommendations 80% of the time. Prosecutors also handle the appeals for bail reduction. Defense attorneys play the weakest role in the decision, as most often judges reflexively defer to the opinion of the prosecutor. At best, the defense attorney's role is to be present to challenge excessive bail recommendations and inaccurate derogatory information about their clients that might influence the bail decision. Lastly, other employees such as clerks, secretaries, and bailiffs can influence the decision or the bail decision in busy courts. When judges have high caseloads, they may rely or defer to secondary figures to collect information about the case. This information influences the bail decisions. The bail setting process has been questioned for many years. There have been different attempts to amend the process. For example, abolition, guided discretion, and expanded discretion. These processes are all outlined in the chapter, but the takeaway is that it is extremely difficult to control discretion, but concerns with the bail setting process and subsequent movements have made bail more visible and fairer to those affected most by the process. Although the system still has its issues, it has much improved over the last 30 years. Now that you've completed the chapter, I want to leave you with some things to think about. For instance, have you ever considered just how many people are incarcerated in local jails while awaiting trial, usually on a felony case? So, in other words, have you considered how many people are incarcerated via preventative detention or because they simply cannot afford bail, yet have been convicted of nothing? In light of Foote's research, is this not quite alarming? After all, are they not presumed innocent under the United States Constitution? How do you think we should change the bail system? And with that, that is the end of this lecture.